this. Okay.
I think, Lydia, if you're just want to go to presentation mode.
Okay, maybe I shared I've got two dual screens, and I shared it. So let me see if I can share my other. 1 second. I don't know why, because I've got dual screens, it's sharing just the other version. Let me see. Maybe if I hide presenter view, I don't even. Now I'm used to sharing everything on Teams. Let me see.
I know.
Okay, now is it full screen?
I just see you.
We don't see it now.
Hilarious. It says that it's showing screen too. What about now?
Yes, now it looks right.
It's the full screen, like it's not in a weird presenter view.
Correct.
No,
Okay.
it's good. Yeah, it's good.
Okay,
Okay,
perfect.
perfect. Well, let's go ahead and okay, I got two more people. We can go ahead and get started with introductions. And again, we're very excited to have you. Thank you so much for doing this for us. I'm Dulce Quintero. I'm one of the team leads here at Casa Nashville. And if you want to just kind of go ahead and introduce yourselves, we're very happy to have Lydia and Jordan from the Education Rights Project present to us today how to better advocate for our youth. And if you want to just kind of share a little bit about yourselves and the work that you're doing, and then just take it from here.
Sure. Yes. Thank you so much for having us. We really appreciate the work that CASA does. We're always so grateful when we have a CASA volunteer or team leader on any of our guardian ad litem cases. So thank you all for all of the work that you do. We know that your work is extremely hard, but it also really matters. And so especially like for those of you who are volunteers, I mean, the fact that you do this just out of your free time, caring for vulnerable children who have, are just wonderful kids and who deserve so much attention and connection. And so thank you for the work that you do. So my name is Lydia Burris, and I am a social worker and the team leader of the Education Rights Project. So we are a program of the Public Defender's Office. So I'll tell you a little bit about it, but I'll let Jordan introduce herself first.
Hi, yeah, my name is Jordan Conley. I am our lead attorney here at the Education Rights Project. We provide representation to families in school meetings and discipline appeals, lots of different types of meetings for our kids with disabilities. And then we also have a guardian ad litem practice where we specialize in educationally complex cases. And we do get some of those referrals from CASA, which we appreciate. And then we also do some educational surrogacy. So that's what I do, and I'm happy to be here with y'all today.
Awesome. Okay, so
and let me know if the audio on my end. Oh, I'm sorry. I said the audio on my end's a little weird. So if there's any point you can't hear me, just let me know.
Okay.
Perfect. Okay, thank you.
So we advocate to ensure that Nashville's children with disabilities get a quality education, graduate from high school, and avoid contact with the juvenile court system. So our program was started in the Public Defender's Office as a way to really prevent or reduce contact with juvenile court for kids who have disabilities or mental health diagnoses, to really try to get the youth that we serve access to the services that they they are legally entitled to give them access to services in the school system, and really keep families together and hopefully out of the court system as much as we can. So we do that, like Jordan was saying, through educational advocacy and legal representation in school meetings. So for the families that we serve, those are cases where we represent the parents through referral. So it's a voluntary program. So here in Nashville, so families are referred to us, and we go to IEP meetings with families representing the parent, and the child, the student, support team meetings, discipline meetings, all of those, which we'll mostly talk about today. We also, our attorneys, Jordan and Emily, are guardians ad litem. So we are appointed through the court to serve and represent the best interest of youth, as you guys know. So that's when we're also really excited to have CASAs involved. And then in some cases, Jordan and Emily can be appointed as educational surrogates to be educational decision makers when there is not one for youth in foster care. And so we have gotten some really amazing referrals from CASA, and we're so grateful for that. And then we do a lot of training, which is why we are grateful to do this work. And so that's one of the reasons you guys have asked us to come today, so that we can help spread some information about special education and discipline law. So for when you guys are working with the families that you have been assigned to work with, when you're going to school meetings, so that you guys really have the tools that you need to advocate on the behalf of the kids that you work with, or to maybe refer cases to us or call us when you have questions, so that when you're like, this doesn't feel right, so that you kind of have some basic knowledge when you're walking into school meetings. And as always, this is not legal advice, but we will give you some legal information. We'll quote, we're not directly quoting the law, but we'll try to give you some information from the law. So we'll briefly talk about different plans for students with disabilities. We'll talk about special education law, how to get a child identified if they need special education services, and then discipline protections for students with disabilities. And this is a kind of an abbreviated version of this presentation. And so we do an extensive version of this. So if you ever have questions or want a longer version of this presentation, you're always welcome to reach out. So when we think about support plans for students with disabilities, specifically, we'll look, the Metro Nashville Public Schools calls them support teams. It's kind of like the most basic level of support. That is kind of just, we would kind of consider it like an intervention plan. I'm sure you guys are familiar with those kinds of plans, just going to the school. Other districts call them different names, but a lot of them do call them support teams or S-team meetings or S-team plans. And so this is, we kind of joke, but also mean it, that this is a plan from kind of the goodness of the school's heart, right? They see a child might be struggling academically, behaviorally, with attendance, maybe a few different things are going on. And so the school team meets together. Typically, this is led by the school counselor, and we bring together different people from the school, oftentimes the parent or guardian, maybe the CASA or an FSW, depending on who's involved with that child. And we try to come up with interventions, kind of a plan that can help support that child. This can be really helpful for a lot of children. However, it's not a document that is legally enforceable. This is not a legal document. There's nothing saying that the school actually has to implement the interventions that are in this plan. So this can be great, but there's not like a legal hook that says the school has to follow it. We do often hear schools say, or parents who come to us are like, well, my child, I think they might need an IEP or they might need a 504 plan, but they're in the support team process, they're going through S teams, and so the school says they can't be evaluated. And the law is really clear that this process is not required before an evaluation for a 504 plan or an IEP. And so for you all to be aware, when you're walking through the process with the families that you serve, with the youth that you serve, that if you hear that language, just to be aware that this process is not required before testing occurs. And then as we kind of go down this line, we get to a kind of more level of support. So we'll look at 504 plans and IEPs. And so here, I'm assuming, I don't know, maybe Dulce, you can tell us if your team, do they go to 504 plans and IEP meetings? Or anyone can jump in. I hope it's somewhat
Yeah.
interactive. Otherwise, you'll just hear us talk.
Yes, we participate in IEP meetings.
Okay, great, great. So similarly, other plans that you can look at are 504 plans. That is a legal document. And so this is a plan that provides accommodations for students with either a physical or mental impairment that substantially limits a major life activity. And the law is really broad when we talk about what that impairment is. And it's also really broad when we talk about what a major life activity is. And so in terms of school, a major life activity can be anything from, thinking, concentrating, breathing, for our kids who have a 504 plan, for diabetes, like, so your like endocrine system, like it's really, really broad about making sure that our students who need accommodations are free from discrimination. And so making sure that the school is providing those accommodations and maybe some services, but primarily accommodations, to ensure that they have access within the school building. These are provided at every single school, every single public school. And so that is something that you can always ask for. And if you have questions about this, feel free to reach out to us. We're going to spend most of this time talking about IEPs, because I know that's what you guys spend more of your time in. But if you ever have questions about 504 plans, please do not hesitate to reach out. Our contact information is at the end of the presentation. So now we'll spend a little bit more time talking about IEPs. I think a lot of people are more familiar with IEPs. So that is the educational program that is tailored to meet the individual needs of students with disabilities. And it provides special education services for students who have been identified as having an educational disability. And so IEPs provide what's called a free and appropriate public education. So do 504 plans, but under the law for an IEP, what that means is that FAPE is really provided through the IEP. And that means that the educational services for students with disabilities are provided at no cost. So they're free to the family. The parent or guardian doesn't have to pay anything. The services are designed to meet the unique needs of each student with a disability. When I think about this, I often think of when I had twins on my caseload that I was providing educational advocacy for, who were very similar in a lot of ways, right? They were twin sisters, but also, of course, right, as every kid is, they were very different. And we're walking into an IEP meeting. They had back-to-back IEP meetings for both of them. And the IEPs were the exact same present levels, goals, services. And I was shocked personally because they qualified for IEPs under different eligibility categories. One had internalizing behaviors. She had anxiety. The other one had externalizing behaviors. She was getting in fights, was much more at risk for expulsion. And their IEPs were written the same. And I was like, this is wrong. We need to make sure that the IEPs are written and are tailored to each unique needs of each of them, not just copy and paste for both of them, just because they're sisters and have very similar DNA. These are two very different girls, and we need to honor their unique strengths. And so we need to we need to start over, because the law is very, very specific in saying these IEPs really have to be designed to meet the unique needs of each student. FAPE means that what's in the IEP, those programs, the school has to provide what's in there. These are legal documents, and the school's got to do what's in them. And it also means that the IEP requires that the special education services are provided from age 3 to 21 for students who have been identified as having an IEP. And then there's specific case law, which is a little more complex, but it just means there's a specific case law saying the IEP must be reasonably calculated to enable each child to make progress appropriate for that child's circumstances. So the bar is fairly high. We want to ensure that students with disabilities are making progress appropriate for their unique circumstances. So we don't want to see kids just like languishing and just, staying the exact same without making progress. They should be making progress. And so that's really, really important. And that's unique for each child. And so if you ever have questions about what FAPE looks like for the youth that you work with, you're always welcome to reach out to us because it's kind of complex. And so, like I said, so FAPE is really provided through special education services. It's what is in that IEP. And that's really provided through that specially designed instruction by a special education teacher. And that means that the special education teacher, whether he or she is pulling the student out and teaching that child in a special education classroom, whether they're pushing into a co-taught classroom, whether that student has a paraprofessional working one-on-one with them, whatever it may be, it means that they are adapting the content of the curriculum. They are changing the way that the instruction is being taught to make sure that child is making that progress. It also means that we are ensuring that every student with a disability has access to the general education curriculum. So the curriculum that all students, whether the child has a disability or not, receives access to the same curriculum. And part of that is ensuring access that kids are making progress, but also to ensure when we think about the history of special education, we know that students with disabilities were segregated, they were institutionalized, they were denied access to education. And so special education now under the current law, it has a much better goal of ensuring access to non-disabled peers and access to gen ed curriculum. And so we always want to ensure that our students that we work with have access to general education curriculum, no matter what, no matter what their disability is, no matter the severity, we always want our students to have access to the general education curriculum. And like I said, we always want to make sure everything is documented in that IEP and it's actually being followed. Do we have any questions so far? And if you do, feel free to put them in the chat if you don't want to like interrupt me, but you're also welcome to interrupt me.
I do have a question.
Yeah, please.
What actions can be taken if a school is not following an IEP?
That's a great question. So there's several different ways. One is, reaching out to advocates and attorneys like us. We have a list of providers that can be challenging, I will say, for especially for youth in foster care, if the parent, the birth parent still has, educational decision making and the kids are in DCS custody, that can become a little complex. Just because of the inherent like conflict that raises. But we're always happy to kind of talk through that. Following up on IEP meetings, making sure things are, written and follow-up emails, making sure it's documented that the schools are not providing what is in the IEP, making sure we'll talk about prior written notice. So don't let me forget that one. I think Jordan will talk about it later. There's a lot of a few ways for dispute resolution, like filing a state complaint, filing due process, mediation. There's also, I feel like I'm just like word vomiting, so I'm so sorry if I'm like giving you too much at once. But we also make sure that, especially for our kids, because we only serve Davidson County, each school has what's called a special education coach, coordinator, or now I think they're called directors, who's assigned to each and every school in the district, including charter schools, who come from the district to monitor compliance. And so we always ensure that they come to meetings if we ever, almost always, but especially if we think there's going to be an issue, or if we know that the school's not providing what they're supposed to. And sometimes we'll even call them beforehand and say, hey, here's our concern. Like today, I'm gonna have a phone call with one saying, hey, here's the concern. I need to talk through this ahead of time so that you can walk into the next IEP meeting that we have, knowing the background of what happened at the previous school, now that my student is a freshman in high school. And they can help monitor compliance as well. So there are ways that you can do that. And always, if you have questions, you're always welcome to call us, even if we can't take the case. And one thing that I can make sure we do is send out our list of advocates and attorneys and what counties they serve.
We had another question. Do
Yeah.
charter schools have to do 504s and IEPs?
I'm sorry, I didn't hear. You go ahead and answer because I didn't hear the question.
Do charter schools have to do 504s and IEPs? Yes, charter schools are public schools, so they do have the same legal obligation to provide a 504 or an IEP. I will say from experience, sometimes it is a bit messier. I would say it just totally depends on the charter school, sort of how much luck you're going to have getting your student good services. Sometimes they're just not very equipped for it, even though they legally should be. But to answer your question, yes, they are required to do so. I don't know if you want to add anything, Lydia.
I'll add with 504 plans. One of the challenges we see is because 504 plans don't come with funding like IEPs do. Like there's not an additional funding mechanism for like per pupil funding. So schools don't get extra money. So we see that is one of the challenges of getting students identified for 504. It is confused. 504 plans for some reason confuse a lot of schools. And so I think that is a piece of it as well. But just as there are coordinators and coaches assigned to each of the schools and charter schools for special education, there are also the same kind of professionals for 504 plan compliance, and they also cover charter schools in Davidson County. So if you ever have a question on who that person might be for your student that you're working with, you can reach out to the district or to us, and we're always happy to share like who that contact information is, who that could be, because they're also assigned to each of the charters as well. But yeah, charter schools have to follow the law too.
Perfect. And then we have one more. What is a normal time frame to initiate an IEP for a student, especially if they start new school with the IEP already? Jackie, are you saying like the evaluation process, or just like, so I guess to answer what I think you're asking is an IEP has to be like substantially in compliance as soon as the student comes into the new school. They should meet to make sure the IEP is tailored to that school environment as soon as possible. Is that what you were asking?
Yeah, so to be specific, I do have a child that just entered foster care, and she was moved from one school district to another. And she has an existing IEP, and it's already going to be September, and they've been great about meeting. We've had a ST meeting, and I'm just curious when the actual, like, when is it too long for a child to waiting?
So the school is supposed to provide comparable services. Like when the student moves, that can be from state to state, from system to system, from school to school. They should be providing comparable IEP services to what is in the previous IEP immediately. It is essentially like illegal for them to be out of compliance with the IEP. So if she's a student with an IEP already, they shouldn't be having support team meetings. They should be having an IEP meeting. Whether that's to work off of the previous IEP and tweak it, or if they want to totally like redo it for this new school environment. But I would probably put a request for an actual IEP meeting in writing to the principal to ask that that happens.
Okay,
Just
should
because,
should a CASA or should I have the foster parent do that?
is there an educational surrogate
Or is
involved,
the
or is there
parent?
a parent involved, like a biological parent involved?
Yeah,
No, okay. So yeah, it's difficult because with foster parents, they don't in Tennessee, they don't get educational rights until the foster child's been with them for a year plus. So
And if the birth parent is not making educational decisions.
okay, so if the birth parent, so if I guess we're allowed to speak specifically about our cases, right, in this kind of group, right?
Yeah, just don't give us the name.
Okay,
Right.
so
Just
if I
not-
have one parent that OD'd, passed away, then the other parent is still on drugs and not getting help yet. So there's no contact. They're not having family visits. But when they did transfer the school from one Metro Davidson area to another, the bio mom was on the Zoom, but didn't speak. But so she is still involved, but can't, like,
she's not
she's not able
participating.
to
She could
Yeah.
still retain educational decision making. So I think yeah.
In this scenario, it's difficult because the school probably won't want to appoint a surrogate because rights aren't terminated and because there's a parent still around-ish. And the court will probably be hesitant to appoint a
Okay.
surrogate as well because the parent has been on meetings. But I think what you can do is the CASA is request a school meeting with any other support folks for the adult that are like, would come to the meeting and
Okay.
ask, like, provide the parent information, ask that the school invite the parent. And I've had success with this prior. Like, I've told the school the parent's not going to come, they're not going to respond. But here's their information, invite them, give them ample opportunity to respond, to come to the meeting. And like, if they don't come, then we still have the meeting.
Okay.
The
And what
good thing
about a
about
DCS worker? Would that be educational
no,
person?
DCS workers often think they have educational rights, but they do not. And this is the issue we face a lot of times with our youth in foster care. There's like a parent floating off, in the distance, but they're not involved. So the school, they have to make like efforts to get the parent there, but they can still proceed with the meeting without the parent if they're not responsive. So that's what I would do. I would give all the information you can for them to contact the parent
Okay.
and just say like, hey, try your best, but this child needs to have a plan in place regardless if the
Alright.
parent is participating or not. And yeah, I
It's
think
confusing though, because the parent is incoherent, like the parent is not allowed to talk to the kids even on the phone, and she's
hard.
definitely incoherent, a severe drug addict. So I just guess, I wonder if as a CASA, I can
I
ask.
think the school would probably appreciate your efforts and I yeah, I think that's probably the best way to go about it. The
Okay.
good thing is that she already has an IEP. Because if she didn't, that would require some type of like parent signature or a surrogate signature. But since
Right.
she already has an IEP, it should be as simple as having a meeting to make sure that the supports are in place.
All right, thank you. Sorry to take up so
no,
much
it's
time.
okay. If you have any
This is
further
helpful
questions-
because
Yeah.
we'd rather our information be like actually helpful for what you need. And so we can send you guys information on educational surrogates and like who is a parent under the law for special education. And I was gonna add, like, you can ensure that the FSW is invited to the meeting, and hopefully like they can participate and things like that. They're just not able to sign off on the IEP because they're not an educational decision maker.
So I have a question.
Yeah.
Okay, let's say we have a kid that parents are not involved at all. I mean, the kid is in DCS custody, does not have an IEP, but the team agrees that there's something going on and an IEP may be needed.
Mhm.
So you get together as a team and create the plan But I guess who makes the final decision if the parents are not involved? This kid is in the CS custody. Who has the power to make those final decisions, like together as a team, and you just kind of
Yeah.
agree and go with it, and then create this IEP? Can the parents later return and say, "I never agreed to this," and or I mean,
These
what?
are great
Yeah.
questions. Go for it, Jordan.
Okay. Yeah, so this is a scenario actually we've gotten quite a few CASA referrals for. So the issue is that typically, so this sounds like a case where a surrogate would be needed because in order for an initial evaluation and an IEP to happen, that is almost the one time where a parent's signature is actually needed, like somebody with legal education decision-making power. If the child already has an IEP, the IEP can go into it, like can continue being in effect without parent signature. So if it's a potentially new IEP, somebody, either a biological parent or a surrogate, would need to be involved and need to sign off on the evaluation and then the IEP. The issue that we run into a lot is that unless rights are terminated, the school themselves will not appoint a surrogate. They are very afraid of, trumping biological parents' rights. And so the way that we've gone about this in the past with referrals from CASA is that we have given sort of a mock like petition to CASA workers or volunteers to file with the court, asking the court to appoint an educational surrogate. Basically asking the court, saying like, hey, we understand rights are not terminated yet. However, this parent is not involved. We can't find them. They're not, they haven't been at a school meeting in 5 years or whatever. And we have had, in my experience, we've had 100% success with the court appointing a surrogate. The school is just not like comfortable doing it. And so in that way, that's how we've gone about getting kids evaluated and qualified for IEPs where they're sort of languishing in between having rights terminated and having a parent floating out there. So if you're interested in doing that, like we have basically the sample petition in order for a magistrate, and either the GAL could file that or CASA could get that on the docket. And then just either like somebody who wants to be a surrogate can come to that court date. If we're able to take the case, we can do a referral and see if that's something that we could do. But yeah, that's how we've done that in the past. Does that answer your question?
Yes, yes. And one more question. Can you tell us what is needed for an educational surrogate? Like what are the I guess qualifications, or who can be an educational surrogate? Is there any type of training that is needed? If you can go over that, that'd be very helpful.
Yeah, MMPS does a training, so they have sort of like a pool of educational surrogates they pull from. But of course, if you're going through the courts, I think you have to have somebody in mind. Anybody can become an educational surrogate. It's essentially you're just acting as the parent, so no like special knowledge is required. Although it's nice to have some of that background. But yeah, if you have somebody who knows the child well. We've had GALs become surrogate parents before. I don't know if CASA is allowed to be surrogates, but yeah, I
Well,
mean,
that's one of the reasons I'm asking. We're checking on that because I know that there should not be any type of conflict of interest as far as like CASA guidelines go. So I kind of want to learn more about the requirements of being a surrogate. And so yeah, we're looking into whether or not we can be educational surrogates. But I like
and
to
that's
have more
something for us to
information.
think about, maybe doing a training for
We could
like
easily
surrogate
do a
parents.
training for y'all. Like if you
Yeah.
like we could do a more extensive training about special education law for if you guys were able to do that.
Yeah, or executive director is looking into whether or not we're allowed to do it. But if we are, then I think it would be great. And I mean, please, people, jump in if you want to. But I think it'll be very beneficial to have a training through you, to see. But as far as requirements go, it's just anyone that is willing to do it, that knows the child well. Anything else?
Yeah.
And
No,
also,
yeah, there's no special requirement. I mean, if you're doing it through MMPS, they require that their surrogates go through a training, but like
Okay.
legally, no, there's no requirement or special knowledge level.
Okay.
Right. They have a manual that I'm happy to, MMPS has a manual for special ed surrogates. And I would say, so and typically to go through the MMPS process, they appoint a surrogate for specific cases, like Jordan was saying. Typically, it's really rare for them to appoint someone when parents' rights have not been terminated, just in case the parent does decide to start, and if the goal is reunification, they are, healthy and they're working their plan and they want to come back into their child's life, and things are going well, like they don't want to step into that and say, well, actually in the process, we've reassigned your rights to another person. And then that becomes really uncomfortable. And so it's really rare that MMPS would appoint someone for themselves. So that's why there's the other process to go through the courts.
And just to add, to answer the other part of your question, I don't think I got to, is that parents can come back into the educational, like biological parents can come back into the educational scene at any point and assert their parental rights unless those rights have been terminated. So correct me if I'm wrong, Lydia, but so like, this is not like giving educational surrogacy to somebody does not strip the rights from the biological parent. It's just sort of like subbing in while they're unavailable. So if the parent ever did, get treatment or whatever and wanted to come to school meetings, ultimately their say would trump. So yeah, I hope that helps.
Yeah.
Okay, thank you.
But it could also be, or like a grandparent or someone else. I mean, there are other people who have a vested stake who could become a surrogate as well. Any other, and I'll send, when we send some follow-up information, we can definitely send more information about surrogates, since that is really applicable for the work you all do.
Oh,
Awesome.
yes,
Well,
please. Then that
yeah,
will be
okay,
very helpful.
definitely. Well, we definitely will not make it through this presentation, but I would rather the information be useful for what you guys do. So I'm so glad that that was helpful. So we'll talk about how to ensure that students qualify for an IEP if they need to. So when we look at who is eligible for special education, the law says it's a child with a disability who needs special education and related services because of that disability. So when we talk about that, we're looking at a child's educational performance, and their that educational performance must be adversely impacted by the disability. And when we look at educational performance, we're talking about attendance, behavior, and grades. We're looking at all three of those. And so, hold on. Let's see, it'll click. There we go. So when we're talking about that, we also look at child find. So child find is under the law, means that it's the school district's duty to identify, locate, and evaluate children with disabilities who need special education related services. So it's really the school district's obligation and responsibility to look at their students in their district and ensure that they are evaluating to ensure that they're providing special education services to the students who should qualify for an IEP. And that means that when a disability is suspected, as soon as it's suspected, they should evaluate. They shouldn't wait. They shouldn't pass the kid on for years and years, and then say, "Oops, they probably should have, evaluated years prior." As soon as the school district suspects a disability, their obligation to evaluate is triggered. And so when we think about what that might look like for suspicion of disability, sometimes it's helpful to think of it as kind of red flags of, okay, we're working with this youth. Maybe we're starting to suspect disability. What are different categories we could look at? So we think of it as academic performance. So grades, behavior in terms of suspensions, expulsions, ISS, are there, their behaviors, is it different than that of their peers? Attendance, are they missing a lot of school? Are they being sent home regularly? The child's communication in terms of like speech and articulation, as well as if they're understanding what you're saying, if you're able to understand what they're saying, any concerns with mental health, and then any sort of school or parent concerns. And so that is just can help you kind of guide your thought process of whether or not you might suspect a child might qualify for an IEP, or that they just need to be evaluated to see if they would qualify. And in the state of Tennessee, we have 16 different eligibility categories. So these are the categories that a child must qualify under for an IEP. So for a 504 plan, like I said, it's really broad where a child might qualify. For an IEP, it's very, very specific. Each of these categories have really specific state criteria that an evaluator is looking at. They're doing rating scales, they're doing an IQ measure, observations to see if a child meets these categories. And then they're seeing, is there actually an adverse impact? And does this child need special education services? And so this can be helpful when you're thinking through, okay, we have these red flags, we suspect a disability, where might they qualify under? And so, as you can imagine, because we work at, the goal is to prevent contact with juvenile court or reduce contact. A lot of the youth we work with qualify under emotional disturbance, which has a horrible name. We all know that. A lot of our kids have qualified under intellectual disability, so their IQ and adaptive skills are under 70. Other health impairment is a category that includes a bunch of different diagnoses, but specifically includes ADHD. But those are the 16 different categories that can help you just kind of get familiar with the categories. And so we always tell people, when you think a child might qualify or you suspect they have a disability, ask for an evaluation to the school in writing. You can do it in email. We have evaluation, like sample evaluation request letters, because that really puts the school legally on hook to do the evaluation and to schedule a meeting. Jordan talked about kind of some of the challenges for youth in foster care when there isn't a birth parent actively making decisions educationally. And so maybe a surrogate might be needed to sign initial consent for evaluation. If you got questions, you're always welcome to reach out to us when you're thinking like through that calculus of whether or not a child needs an educational surrogate. But another reason it's really powerful is for kids, when they're in the testing process, discipline protections are provided to them just as like they already have an IEP while they're in the evaluation process. So if a kid's at risk for expulsion or multiple suspensions, this can be really powerful as well. So let's say we've requested an evaluation. Now the team comes together, we have a support team meeting, we talk about why we suspect a disability, we've given the school psychologist or whoever's doing the evaluation our reasons of why we suspect a disability. The school, whoever is signing consent, the parent, the surrogate, whoever it may be, the school's required to do what's called a full and individual evaluation. So the school's required to test in all eligibility categories, so the list right here. And they do this really long, extensive evaluation, hopefully really high quality. And the evaluation must be completed within 60 calendar days. So the team will then come back together, review the evaluation, discuss if the student meets that state criteria, and then talk about whether or not, if they met the criteria, whether or not the disability adversely impacts that student's educational performance. So does it adversely impact their attendance, their behavior, or their grades? And does this child need special education services? And if so, the kid qualifies for an IEP. And the whole team makes that decision if they're eligible for an IEP. And so that's when, for that initial IEP, the parent has to sign off on the IEP for the child to get special education services. So that's when it really matters to have a parent present or an educational surrogate if they need one. After that, the parents can skip the meetings or not show up or whatever's kind of going on in the parent's life, especially for our kids who are in DCS custody. But at that initial IEP meeting, it's necessary for someone to sign off and give initial consent for an IEP. Does anyone have questions about that? Kind of from the surrogacy piece? No. Okay. All right. And so I'm not going to go through this piece but this is just kind of the different parts of an IEP. And you guys will have these slides. Trying to think if anything's kind of specifically necessary. Okay, and Jordan's going to talk about services in terms of LRE.
Yeah, sure. I'll kind of go quickly so we can get through as much as possible. If there's any questions, you can throw them in the chat. So part of IDEA, the federal special education law, sort of cornerstone of that law is something called LRE, or least restrictive environment. And what that means is that children with disabilities need to be educated to the maximum extent appropriate with their peers that do not have disabilities. And that's because, that's a part of the law that we really appreciate, because special ed has, an ugly segregationist history of our kids with disabilities. And so we want to make sure that we're not warehousing them separate from their general ed peers, and making sure that they are able to be integrated into that general ed curriculum whenever possible. So the graphic that is here sort of goes from the bottom is the least restrictive setting that our kids with disabilities spend their school day in, to sort of the most restrictive. So they can, some of our kids with IEPs spend all day in general ed, and they may have what's called, or they may, just have like accommodations or very minimal service. Then sometimes our kids have what we call push-in service, or an inclusion classroom, where there's a special ed teacher as an additional teacher in their classroom, giving the students with IEPs extra support. Then we have some pull-out service that they can receive. So if they're behind in a certain area, like reading or math, they can be pulled out for certain portions of the day to get small group instruction and work on those deficits. Those can also be inclusive of behavior services as well. So we can give specialized instruction to our kids that struggle with behavior on different coping skills and things like that. And then as we go up the restrictiveness ladder, we see kids spending more and more time in the special education classroom. So some of our schools have what's called low incidence rooms for our kids with higher special education needs, where they may spend all day in that classroom. And then some of you might be familiar with our special day schools here in the district. There are 5 special day schools: Merle, Cora Howe, High Road, Genesis, and Harris Hillman. Did I get them all? So if you have a kid in one of those schools, that means that they have an IEP and that they are receiving all day special education service. Most likely because they have behaviors that can't be managed safely at their zone school. And then we have hospital, homebound, or residential facilities as sort of the most restrictive schooling environment. The most important thing to note about least restrictive environment is that a child should not be stuck at any rung of this pyramid ladder. Children should be able to decrease their service as necessary, or increase their service if their needs require it. And we should not be moving kids down or up this pyramid without data to back up the move. So a lot of times we'll get schools who want to move kids to a special day school environment really quickly because they can't handle them. I had a kid last year where he had been at school for 4 days before they called a meeting to try and move him to a special day school. That's not appropriate. We don't have data. You haven't given a kid a chance to succeed at the zone school. And so we were able to challenge that, but sort of a basic overview for you. Sorry, I'm trying to go fast. Another thing to be aware of at IEP meetings that you're attending is parents' rights, whether it's a surrogate parent or a biological parent or a guardian, maybe that has power of attorney. Parents' rights are a really important cornerstone of special ed law as well, because parents know the child the best. So the parent has a right to give informed consent. They should be, told what the process of evaluation is going to entail. They should be able to see the documents before they're signing anything. They have the right to participate in IEP team decisions. A lot of times schools will try and call meetings at times that don't work for the parent, or without enough notice for the parent to take off work. And so the parent has that right to participate in IEP team decisions, and they have the right to meet at a mutually convenient time. We've been getting a lot of schools where they're like, we only have planning period from 7 a.m. to 7:52, and you have to come on Tuesdays or else you can't have a meeting. That's not what the law says. We have to find a mutually convenient time for the school and for the parent. The parent has the right to access the child's school records within 45 days after the request is made or before any IEP meeting. They have the right to receive adequate notice of meetings, and they have a right to receive a prior written notice, or sometimes it's called a PWN, and which is a document that outlines what the school suggested to do in the meeting, and then what they either rejected or accepted as a change to the IEP. And they have a right to receive their procedural safeguards, which is a booklet of parent rights, and it outlines anything you could think of for the parents.
And I was going to say, I think for the prior written notice, and that's another really helpful tool that you were asking about when the school's not implementing with the IEP, that can be a way to just say like, hey, you know, my child is supposed to be getting language therapy twice a week for 30 minutes. I know that right now there's not a speech language pathologist hired for this school. Just want it documented in the prior notice so that when there is one hired, he will get compensatory services to make up for all of the hours that he hasn't gotten. Or I asked for a functional behavior assessment to address my child's behavior. You said that you weren't going to do so. I just want that to be noted in the prior written notice that I requested a functional behavior assessment. You said no. And so that, and I will say this is a tool that can come across very assertive, and sometimes schools don't like it because you're asking them to document in their own legal document that they're not potentially not doing what they are supposed to do legally. But this can be a tool, a really positive tool to get what you want done and to ensure that the school is doing what they're supposed to do. So I will say, when I first started my career, I asked this real almost like aggressively. I was like, just put in the prior written notice, and that makes schools mad. Now I've learned to ask it really kindly, and schools are like, well, what if we did this instead? Or I'll say like kind of just politely, we'll turn to whoever is writing, like the special education case manager or the coordinator, whoever's at the table, and I'll say, hey, can you just put that in the prior written notice? Or just like, this is what we mentioned. Just want to make sure we, you know, don't forget this since we've talked about it. Can you just put it in the prior written notice? And that is a better tool that I have found of just making sure that we're all on the same page. And if they say no, then I follow up with an email after the meeting and just to document it to prove that they aren't doing it. But that can also be a really powerful tool to show when schools are not implementing what's in the IEP. And I think it might be, since it's because we have an hour, right?
Yeah,
before
we
start
do.
this-
I don't know. I
Yeah.
hope it doesn't kick us out after the hour. I
No,
don't
you're
think it
good.
will. So we're
I thought
good.
maybe
We're
that
good. I
so the
mean,
next part is we can, and Jordan, you can do this part and then we'll stop there before discipline.
Okay. Yeah, so when you're attending IEP meetings, just some advocacy tips for attending these types of meetings. Parents have the ability, like legally, they should be receiving a draft of the IEP 48 hours ahead of time. So if you know, they should be given that. If you can review that before going to the meeting, that's really helpful to sort of be able to point out areas that aren't fleshed out, or you know, correct things that maybe are not, you know, representative of the child ahead of time. It's really helpful to view the document. Ask for district level staff to attend the IEP meeting if needed. We do this really often. You know, it's a large district. Sometimes the quality of knowledge that teachers have varies widely from school to school or from grade to grade. And so having somebody with that special education expertise there from the district can really sort of push meetings in the right direction a lot of the time. and keep things compliant with the law. We want to make sure we're using positive, developmentally appropriate language for our kids in the IEP. These are documents that follow them to every class from grade to grade. They stay in their cumulative files, even if, it's an old document. And so we want to avoid language like violent behaviors or, they do put aggressive in there a lot, which sometimes is appropriate and sometimes it's not. So we just want to make sure that the language is as positive as possible and that is not, stigmatizing or, gives a bad impression of the child to a teacher that maybe has never met them, and reads their IEP first. Ask for clarification if you're confused. There are a ton of acronyms in education that I'm still learning some of them. There's something new every year. If you're confused, the parent is definitely confused. I'm sure you're not the only one there that's confused, so feel free to ask. Make decisions based on data, especially if we're, putting kids in more restrictive environments or we're taking service away. Some, resources should never be a reason to deprive a child of the service that the data says they need. So we'll sometimes hear from teams, well, we don't have somebody who can do intervention at that time, or, we don't have somebody that can provide this, or we don't have an aide or a paraprofessional, right? Like, if the data says the child needs that, then it's the school's obligation to find that resource. We want to ask for actions proposed or denied to be documented in the PWN, which Lydia just described, and then wait to see an updated IEP before signing if you're the surrogate or if you're there helping a parent. Sometimes schools would want to get everything done that same day, so they'll be typing while we're in the meeting and then print it out and you haven't had a chance to review what they've just changed. The parent shouldn't feel rushed. They have 14 days to look over that document and to sign before the changes go into effect on the 15th day. So there is no rush, and try not to feel that pressure in the meeting. And we do, we didn't get through everything, but we do have more information about discipline, protections for kids with disabilities toward the end. So if you have any questions about those types of meetings or rights of kids who are getting suspended or expelled, feel free to reach out to us.
Do you, are you able to share this PowerPoint
Yes.
with me so I can send it out
Yes.
to everyone? Okay.
Absolutely. That will definitely send you that. Anything else that would be helpful or any follow-up questions?
Oh, you're gonna send us your direct contact, your emails?
Yes,
are
and
in-
our at the very last slide is all of our contact information. And if you just Google us, Education Rights Project,
Okay.
you can find us there as well. Or honestly, reach out to Kathy Crum.
Okay,
Mhm.
this was so helpful. Thank you so much. I mean, it was great.
Thank you so
I
much.
appreciate
We
it.
really
Thank you.
appreciate you all.
Yes. Sorry I took so long with those questions, but
No,
it's-
I'm glad it was useful.
yeah, the educational surrogate is something that has come up a couple of times, and I want to really understand that. So what I will do is I will share the PowerPoint with everyone. I will share it with the other team leads and they can distribute and your contact information. And we'll probably need to do another training.
Yeah, absolutely.
part
And we'll send
two.
out all the information about surrogates too.
Yes, please. Thank you. Yeah, well, let's talk soon and maybe plan a second part because I think that obviously we didn't get through all the information and this is very valuable information for CASA. So we really appreciate you.
Great. Thank you guys so much. Have a good rest of the day.
Thank you, you too. Bye-bye.
Bye.
Bye.